that form the criteria that you use when you're making your decision. Right now, where are they?
They're in case law.
Well, okay, but I mean...
They're in our decisions. We will write about the quality of the neighborhood.
But when an applicant, I turn the question back on you. When an applicant comes into you and says, with an application for a special permit, how do they know whether you're going to, do they get any sense at all whether you're going to be inclined to grant the permit or not?
Well, if they've been to the planning board and the planning board says this is a bad idea, they should have a pretty good idea that...
They wouldn't have been to the planning board.
In many cases, they wouldn't have been.
They would go directly to you.
Right.
But they would have gone to you.
No.
Well,
only for scenic roads.
I don't see
on
where
scenic
in
road.
I don't see where in the bylaw change you're suggesting that different properties come to you than do currently. Can you help me with that?
We're not. What we're saying is that what we're attempting to do is, Marissa was saying, I was following up on what she was saying, we were attempting to codify so that the decisions, at least with respect to historically significant buildings, there was a set of standards where people, a roadmap where people could sort of get an idea whether they were likely to get a special permit or not. Right now, it's case law. I mean, you know, who knows case law? You do. You're an attorney. I don't. I'm an architect. And so we're saying, could we develop a set of standards that people, everybody, not just attorneys, could understand would apply under certain circumstances, specifically historical structures?
Well, I think what you're asking for is to, you're saying codify, but what I'm hearing is restrict. Because if you sit down and try to write on a piece of paper every possible thing that might be considered detrimental, you're tying our hands. We no longer have discretion. And by its definition, these permits are discretionary. So I'm uncomfortable with having little holes that I have to check off each time. And did I consider this? Did I consider that? Did I consider this?
But on the other hand, if you don't do that, or at least something like that, then your decision could be appealable. What you need to have, but the chances of defending it are greater if you at least have some predictability.
Well, I mean, the rationale. I think our decisions are intended to be sufficiently substantiated that they'll hold up as best we can. They don't always, but see, I just want to make sure everybody has a chance. I know you guys are.
I'd be interested in Joel's thoughts about codifying that kind of explanation to the public, what detrimental means in the bylaw.
Well, I don't think the idea would be to codify it, because I agree with the point you made, but I think the idea would be more to spell out general criteria that the board would be considering, but not a codification.
Okay. So are those criteria, or those criteria, guidelines, or whatever? Are you? I believe that historic and planning are using some already. Is that correct? Is that not correct?
Well, actually, in the proposed amendment, there's a set of criteria. It may not be the appropriate set of criteria, but if you thought it was a start. Right. Review and propose replacement, paragraph 2.
2 or
Part 2,
Paragraph 2.
Okay. So the special permitting granting authority shall consider the following: conformance with zoning bylaw, historic and cultural contribution of the existing structuring site, relative practicability of alternative development scenarios, including particularly expansion of the existing structure, compatibility of the proposed construction with surrounding architectural and landscape contexts, including building massing, relative street setback, architectural character, exterior building materials, extent, regrading and paving, appropriateness of landscaping and other factors may be relevant, and then planning board and historic commission recommendations.
That's not an expensive list.
No, I mean, I
Consider
think that stuff is current. Right.
Well, is that written down anywhere?
No, it's not. So your idea is that it should be written down.
Yeah. Now, whether or not it has to be bylaw specifically, or whether it's
It
part of-
doesn't. I mean, as long as everybody understands.
I certainly,
Those are the rules of the game.
I completely agree that those are worthwhile goals.
If I may speak, I'm Gloria Cole, I'm the co-chair with Melissa of the Historical Commission. Oftentimes we're the first step for
Yeah.
somebody owning a property that's, and they come to us and they ask us, what are our chances, or what do we do next? Or they'll come in front of us and say, we want a total tear down because that gives us the most flexibility. And the unintended consequences of that could be that they may tear down and then may not ever be able to build if they can never get a plan that's going to be acceptable to everyone. But we feel like there's a tremendous amount of pressure to go for the total tear down. We see brokers listing the properties as vacant land, these historic structures in these nice little neighborhoods, and they're sitting ducks, frankly. And if we're able to tell the folks that come to us first time, and very often they're people that have moved to town for the first time, they really don't know the process. And if we can tell them these are the criteria that if you need a variance, these are the things that are going to be taken into account, and we will sign off or whatever. We'll say we approve or don't approve your plan, or we impose a 6-month delay, and you're welcome to come back. So I'm here to advocate for more clarity for the applicants who are spending a tremendous amount of time and energy trying to do the right things most of the time. They want our input. We get love letters from most of the people that appear in front of us because they're grateful. They've gotten terrific architect and historian review of their ideas, and they get a lot of free services. So, but we can't say to them at this point, we know on a regular basis that consistently these are the standards that are not necessarily applied, but these are the guidelines that they're going to look at, and if you can meet these guidelines, you have a much better shot.
So long as you say you have a much better shot, you cannot say.
No, absolutely. We would never say that. But they're coming to us and looking for, can you give us some help? And it would be helpful to us if we could come together with a set of guidelines for it that are considered. These are among the considerations.
So help me understand. You guys do a great job and you work real hard at it, and I think the results we're all the better for it. Do you not currently have some guidelines that you use that are sort of like this?
We have our determination of what's a significant building, and if it's significant, whether or not, then we go to a design review process, whether or not this significant building, proposed changes to it
And
are
it takes
appropriate.
into account those
It does.
landscape
It
and
takes
all that
into account all of those things.
Now, is that stuff that is in the, I don't think that stuff is actually in the bylaws.
No,
That's
it
what
isn't.
is, right? Does it need, are you saying that it needs to be in the bylaws, or is it that you just want to make sure everybody knows what it is?
We don't care if it's a bylaw change. We all need to be on the same page.
All right,
But
thank
the
you.
difference though, Mark, is that they just wait out the 6 months and
That's
then
right. They have a
it
blank
doesn't matter
check.
whereas
They have a blank
for
Right,
you
okay.
guys, you're the final word.
Right.
Right.
Well, I would recommend anybody just try waiting out 6 months, personally, but.
But if they wait out the 6 months, assuming it's a non-conforming lot, tear it down, then, as Joel said,
They got
they could be in trouble.
Got a community garden.
Yeah.
I would just like to say that in case you don't know the numbers, for the last maybe 4 or 5 years, we see between 60 and 70 houses a year, and we typically impose 2 or 3 6-month delays. So that's a very low percentage. It's not at all like, I think sometimes people think we're doing that, but we don't actually do that very often.
But you do stuff with the other 58 of them to help.
But we
them.
work on the other ones, and that's right. But when it comes to actual, most of those 6-month delays are total demolition, obviously. So, but our numbers are not very big. But with the Gale decision, it sort of seemed like they would grow. I guess is what we were concerned about. We're concerned about that. And other towns are too, as I said. I mean, there's other towns. Newton's hired a long-range planner specifically to deal with this. There's other issues that come up. Klein is constantly, I think it's something that everybody's grappling with. It's not just Weston. And so it behooves us to try and, figure it out for us and for everybody else, really.
So Al, what, I know you have an agenda this evening. What else would you like to try to accomplish?
Well, I'd like to ask people if, recognizing that this is a discussion. We're not even sure we're going to be putting an amendment on the warrant. We're just floating ideas around. But any comments or input that you might have would really be helpful. And if you just give us your name before you make your comment, that would be great.
And address.
Go ahead.
Mario Alani, 12 Bayberry Lane. When I initially read this proposal, draft 4, I didn't get what you said about this only affects historic houses, because when I read it, it changes the definition of replacement single family, and it doesn't mention historic in that. So it basically says replacement construction is not permitted, period. So then, unless you meet criteria of section C, and then there it doesn't really, basically says historic ones are allowed under certain conditions, but it doesn't say anything about non-historic ones. So that got a little confusing. And then it also refers back to the definition of what is historic, which I feel is a general bylaw, which is a little bit of a moving target, because if you change that definition in a general bylaw, it takes a majority vote, yet you're affecting people. You're really changing the zoning bylaw, which requires a 2/3 vote. So I don't know if that's an indirect way of...
First comment was clearly an omission. Second comment, the definition just basically reiterates the standard that's already established under the demolition delay bylaw. So it's not really new. It's a reiteration. So it's for clarity, so that people won't wonder what it is and they don't know that they need to go to the demolition delay bylaw to find it. That was the purpose of that.
If I could jump in, the gentleman makes a good point, though. I mean, we probably, because you're absolutely right, that you can't amend a zoning bylaw by amending a general bylaw, and that's a very good point that it's only a majority vote by 2/3. I mean, this would be stronger to say as of October 2012, that sort of thing, to fix it in time, so that.
Oh, sure, okay. All right. Yeah, I understand that.
And just on the first point, I will say the replacement construction is not permitted on lots not conforming, not period, but as to lot area or front and or frontage. And that is meant to capture, I think, primarily, in other words, the undersized lot. So it's not just any
It's not historic.
non-conforming.
It's not just historic. It's all of them.
Right.
And that's not the intent.
That's not the intent.
That's not the intent.
Okay.
Right.
And I think that there's a lot. I've heard a lot of concern about that particular.
Yeah, that wasn't the intent.
Okay.
So
That's important.
Hi, Denise Mosher, I'm at 84 Wellesley. So my house is one of these houses that will be affected by this, and I just have to say I'm shocked that I just am hearing about it today. And I look around and not a single one of my neighbors, if I called probably 90% of the people on my street, not one of them would even know that this was up for discussion tonight. And if this is something that's going to be potentially on a ballot soon, I think that's just a travesty.
Well, just so you know, this is just for us to understand what is being proposed. It hasn't been proposed, and it may not be proposed. So we just wanted to talk amongst ourselves, and you're all welcome to hear because it's an open meeting. But it's not, it hasn't been.
Jim Gutowski, I'm at 17 Columbine Road. And we have a little bit of a different situation. We're actually submitted an application that has somewhat less of, I think, an impact. It's not a non-conforming lot. It's not a historic property. It is not on a scenic street. Yet, in my experience, and of course I'm not an architect, I'm not a lawyer, but it is just as confusing and as misaligned and as disturbing a process for a project that we're putting together that involves building into a setback literally 8 square feet. And the experience of going in front of the board, there wasn't any sense of consistency around the data that was exchanged even amongst the 6 members of the board. There was no clarity around the process that went through this. And, you kind of feel like you're on trial, for something that's relatively minor. So, this extends from the largest and most impactful kind of thing to the very smallest minor modification. And now we're in a situation where we may be delayed months and months for, again, a spot that's literally 8 feet wide and about 2 feet deep. And I'm just as disturbed as you are.
Well, that is a slightly different situation, and it is the way the bylaws are written. So
it's a different situation. I explained to you, or I tried to. I really tried to. That we're this is just the tip of the. We're just trying to work out what the protocol is for this scale decision. It's a different, for us anyway, on the planning board. It's a different set of circumstances. So you and we are, we wound up in the same boat. And I apologized for that at the time, and I still mean it. I really empathize. And if I were in your shoes, I'd be just as concerned as you are. We're just trying to do the right thing, and we're trying to make sure that we follow the right steps. So that unfortunately, you were the first one down the pike, and if the planning board has anything to do with it, it's not going to be months. We're just trying to figure out what we're supposed to do. That's all.
Al Grigg, Shea 11, Shea Hill Road. My question is very specifically the topic that you're dealing with. When conforming and a non-conforming lot can be 6 inches in terms of the distinguishment between the two. And you look at areas. Why are you doing this just for non-conforming lots? I mean, what's the thought on that? I mean, you can have a neighbor with 1 extra foot next to you who's a conforming lot and not be subject to your rules.
Because conforming lots, again, going back a year and a half ago, if you were on a non-conforming lot, even if your lot was 6 inches under the limit, you needed a variance to build a new house on that lot. I mean, it was almost impossible, even though your neighbor who had that extra 6 inches could rebuild by right. It's the way it is in zoning land,
But not with the application to your concerns. I mean, the application to your concerns is, nature and conduct of the building in that context. And because you have 6 more inches doesn't mean that the next neighbor should not have that application. If you're talking about historic preservation, I don't think.
Again, there's a different set of rules for non-conforming lots, even if it's slightly non-conforming than there is for conforming lots. And if it's like.
So you'd rather preserve a historic building on a non-conforming lot than one on a conforming lot?
No, I'd rather preserve them
Well,
both.
that's what you're suggesting, though, to go through the process.
We don't have the authority to do it.
That would really be taking away people's rights.
That's right.
To go and
But
say
those
that
people who are on the
conforming
conforming don't have to go through the proposed approval process.
Well, they don't anyway.
Because
They don't anyway, with historic or
Well, I
not.
mean, if the town wanted to, and many towns have, I mean, look at Nantucket, for example, they have very strict limitations on conforming and non-conforming lots alike as to what you can do to your property. In the historic, or, yeah, well, in their case, they're all out. We haven't, as a town, voted to do that.
I don't think Weston would do that. I mean, we're not interested in actually infringing on people's rights. We just want to clarify what the process is so people will understand it. That's our motive.
I just don't think the application of your concerns is delineated by 6 inches, and it can be by delineating a non.
At the moment, given the way the town's voted for the protection of historic properties, it matters. Yeah.
Jonathan White from 54 Pinecroft. A couple of comments. First one, I'm very appreciative of adding historically significant to the definition, because I've been reading it that these criteria affect all non-conforming, so it's just historically significant. I would agree with some of the concern expressed there, and it's always been a balancing act. Non-conforming lots always suffer a little bit in value in comparison to fully conforming lots, but I think you should recognize that the more that you codify, and I'm still saying we're codifying even though it's guidelines, that these lots are going to be treated differently if they have older houses on them. You're really affecting the value.
But they're better off than they now with the guidelines than they were a year and a half ago.
I don't think so. I don't think so.
When you needed a variance?
No, you didn't need a variance. If you needed a special permit before, as long as you make it conforming with setbacks, you did not need a variance on a pre-existing non-conforming lot. You only needed, well, until 2 years ago, you only needed a finding. Now it's tougher. We made it a special permit. This is going to make it tougher again. But I mean, it's definitely going to make it tougher for people who have those lots that they bought, to sell them if it's an obvious tear down. And I won't even place a value on it tonight, but it will separate the values more. The only other thing.
But just to interrupt, and I'm sorry to interrupt.
Yeah.
But they're going to be coming for a special permit review anyway.
Mm-hmm.
So if you're considering buying a lot, wouldn't you feel better knowing what the guidelines are than just throwing the dice and hoping for the best?
I'm thinking as much of the people who have bought into the present system, who've been here for 30, 40, 50 years, having older houses. This is
even then, wouldn't you feel better?
This is going to really subtract from the value of some of those houses. The more you codify that we're going to look at this, and this before we let you do it. Whereas, I agree, the same older house on a conforming lot won't have that problem. And I can tell you, there's so many people in this town who bought houses, they don't even know if they have a conforming or non-conforming lot. I was talking to one person this weekend about it. She said, well, it makes sense to make it a lot tougher, for those properties. And I said, your lot is non-conforming? No. But the only other thing, are we still having a public hearing on this at 9 too?
Yeah.
The only other thing I'd suggest is that right now, historically significant building is not defined per se in the demolition delay bylaw. You can read that and you can pretty much figure out what they mean by it. But one thing I noticed is that the threshold for whether or not you're going to have a historically significant building is you have to be on one of 3 lists. And I think if nothing else, if this is going to come up for hearing, the town should publish those 3 lists. One is you're listed in the National Register of Historic Places. That's an easy one. Generally, if you own a house in that list, you know it. One is included within a significant area or further studied area, inventoried or outlined by the Commission in 1993 for Historical Resources Survey. And the third one is documented on a Cultural Resources Inventory form prepared by the Commission. I noted that that last one, the Cultural Resources Inventory, has apparently been done recently by the historical, and everything on that list isn't necessarily a historically significant building, but I think it's a starting point if this is going to come up for a vote. People should see if their houses are on that list, and if you're on that list, then you go to the next criteria, which looks at various components, whether they're going to deem you significant. But I think it's very important for people to know if they're on the list before this is voted on.
Just one thing to say, Jonathan, if you go on the Historical Commission's website, all the houses, specific numbers in each net of houses that are on the National Register and in the areas are on the website.
Yeah, I've seen the maps.
It's not just the maps, it's also actual addresses.
Now, the Cultural Resources Inventory is not available.
That's actually on there too.
I asked for it, and I was told that.
Did you look on the website?
I said I couldn't find it, so I asked, and I was told
I'll
that.
I'll tell you. I'll show you where.
Yeah, so that ought to be published because
It's
I'm
on,
not the best with computers.
It's on the website.
I'm not the best with computers, but let's just publish it. Just publish it.
Can I say one other thing? I feel like because I have an old house, which I love old houses, I've done a good job, I think, to try to maintain my house and keep it within the neighborhood, etc. But I feel like when I bought my house almost 20 years ago, I was being sold sort of one thing, and then since then, now I'm on a scenic road, and now I have, all of these, and now I'm going to get a new set of restrictions, and I just don't know, why, first of all, because I like older houses and I'm in an old street, I'm being penalized again, and it's being more restrictive for me and my neighbors than everybody else, and I just don't, that's not kind of what I was expecting 18 or 20 years ago when we bought our house.
Can I address that? I'm Alicia Primer on Historical Commission. You're not being penalized for owning an old house. And some of those bylaws to which you refer, the Scenic Road and things like that, were voted on by the entire town, at which time I'm sure you had the opportunity to vote as well. There are protections for the entire town, including your house. And you're not being penalized. What we're proposing is simply putting in more clear form for the public, just as Jonathan asked for, a codification of what our criteria are so that there won't be gray area when you come to sell your house. You're not being penalized at all. And
it seems like it's definitely going to affect my property value. Yes. And that of my neighbors. And I don't, compared to other people that aren't in a similar situation.
We'll have to agree to disagree on that.
If you can you define for me what practicability of alternative development scenarios, including expansion, is? That's putting your values on what our properties are.
Well, there is some discretion, I believe, on the part of the Historic Commission and
Which they have now.
Which they have now. That's right.
So that's all we're doing.
This is not intended to be the public hearing. This was just intended to be a opportunity for the Planning Board, Historic Commission, and Zoning Board to just learn about what is being discussed and to be a little bit better educated. And I feel like that's been really useful, and really appreciate your time. And you do have some other opportunities for public hearing, is that right?
Yeah, we'll have at least one other hearing session on this. One more question, and then we have to move on.
Mark Henderson, 78 Chestnut Street. What about if the house has lost its useful value, if it's pretty much been run down over the years, and are you going to force that house to be remodeled as opposed to,
Your house would have to be, would have to come before us.
Right.
And we would have to vote it significant.
Right.
So then the question is, if it's significant, what's the next step? And that's part of that whole discussion.
Right. Was your house built before 1945?
Yes.
Okay. Then the commission would take a look at it. I'm not familiar with the house. So
I also don't, if I'm not mistaken, the Historic Commission doesn't take into account what happens inside the house, right?
No,
we don't.
It's strictly outside. So those are.
Although maybe part of the outside is starting to fall apart as well.
Well, we don't really have a method by which we can force homeowners to do anything.
Right. Right, but what if I was going to sell and the new owner would be coming in and be forced to
You can't force anyone to do anything.
to remodel? Well,
No, we can't force anyone.
we can't force you to remodel.
right.
But the intent is to encourage a discussion to maintain it. All right. Thank you all very much for coming this evening, and appreciate the.
Yeah.
And somehow, one of the just like said, I'm sorry, that's just not a grand conception.
Sometimes it does say they never told me that's what they need to do. I guess they need to do. Thank you. That would be here. You go. That would be. Thank you very much.
What you're talking about? The amount of
Yeah, it's four. I know. Does it show that how like
yeah, 31 ranges. Yeah, and then they have a
did you see did you see
it's on there, you can't read it, but they have a summary of every renewal across the street from you. You're not getting that. I just stumbled on it when I was
no, I know. And then you know what I'm saying? My sister called me once and like a tizzy, do you know? And I'm like, oh well, yeah.
I just didn't know lines.
So that's what's the only way is into the back.
It's good. It's all good.
So, you know, and I went through all of what you're suggesting. Why don't you
What precedent really is being set? I was going to find out. Yeah, right. We're talking about bylaw. And they're asking us not only, they're asking us to put the shield. That's my understanding.
How do you even find out?
What I do on Friday night
That's what I was thinking in terms of the CDA.
We're not dealing with it, you know. I think we're saying I'm going to be like, hear about at least for the next 6 months.
Because it does seem to me that they, what I'm looking at, they're concerned that
That's one of the guys. Why are we asking
There may be more comment and feedback on these applications. Everyone in comments wants to get something. Planning board hears something. So I think that there's an opportunity.
But this was, as I understand it, there were two different. Oh, okay, right. So 125. So our front is 146. So it's conforming. Now, I was telling her it's like to see where they go.
Is this conforming or
unless you sell it. Which is bothering me. Everybody's going to sell.
I just wanted to say goodbye, and I wanted to point out one thing which I just pointed out to them is that if people get, I have a house that's a historical house, and it basically doesn't meet any of the setbacks. And if technically speaking, if it burns to the ground, it wouldn't be able to. The setbacks overlap each other. I wouldn't even be able to rebuild the house, but that's not what I'm doing. Right. I call them historical districts, but one issue which people I don't think realize is that if any law is passed that forces a person to rebuild their house to a like kind, to make it the way it was, everybody doesn't have the right insurance. Because I used to own a house that was beautiful, built in 1890. It was a very famous house in Waltham, and if it burned down, the insurance company will only give me a certain amount of money, to build a box. They do it by the square foot. They're not going to replace moldings. They're not going to make fancy. Yeah, exactly. So I had to get a $6,000+ insurance policy for most people in this room isn't a lot of money because it's a wealthy town. But there's a lot of people in this town that do own houses that don't realize they don't have the proper insurance. So if their house burned down, they would give them X amount of money, but they need $300,000 more to rebuild the house the way it was, and they wouldn't have it. So the idea of trying to rebuild a house when you're funding your insurance company and you have a year to do it is totally unrealistic. And unless you're willing to pay for forever however long you own the house, 3 times what you're paying now for insurance, you don't have the insurance that you're going to rebuild your house. Ever do anything? You know what really makes me laugh, and this is totally off the beaten path, is that I go to Brazil like 5 times a year at this point. I love it there. People would boggle their mind that people are so wealthy that they're worried about historical houses and what color things are painted and planting trees, and these people are like living in squalor and are worried about basic things like, is my kid going to get enough to eat today? That's what boggles my mind. I'm going to the Weston Town. I realize, I go there just to throw stuff away, obviously, but I try to recycle. I do recycle a lot, but it's like, I realize, they have that thing where you go and you throw away the stuff you don't want, like your toys and stuff in that box container. So I went in there once, I'm like, oh, this isn't bad. And then I realized a few weeks ago, something, I go to Brazil a lot, I should just take all the toys that are small enough to fit in my suitcases if I have room, bring them to Brazil, and give them to poor kids who can never afford Fisher-Price toys. They know how much a Fisher-Price toy costs. Even for rich people, it's expensive. A little thing of Lego. Well, I will. From now on, I mean, I already collected about a whole suitcase worth of toys in the last 2 weeks. Well, they probably won't get it by Christmas, but regardless, I mean, I know a nurse that works in a hotel, and these kids would be absolutely overjoyed to get a toy.
So nice and sun candy, giving them cavity.
Yeah, we'll do that. So that's what I thought. You too. Enjoy, and hopefully this won't affect you too much. I don't even understand why people are even.
I don't live on a non-conforming lot.
But I mean, what I don't really get is that they need to change something. If you live in a house like mine and it's non-conforming and it burns down, apparently you're allowed to rebuild it. You have to rebuild it the same way, not larger, not higher. Well, under these things. But let's say your house didn't burn down and you went through the process to get an addition put on, but then your house burned down, you would be not allowed to rebuild it with an addition because it burned down. It's kind of a little flawed. Anyway, bye.
I just don't even know
just to see what it feels like. Nothing wrong with that.
Well, he's not going to make a rule. That's what I'm looking I don't have a definitive council. No, the only thing we have is determination of building. Do we have anything? Yes.
That's for variances, not special.
Okay, we're only 40 minutes late. We're going to start the public hearing. RGFA Scenic Road for 546 South Avenue. Who's here to talk about that? All right. We've given this actually about 15 minutes. If you could just quickly.
I don't need a lot of time, Mr. Chairman. Peter Bemis, Engineering Design Consultants. When I last met with you, you were looking for a few more details to be added to the plans, and you were looking for a letter from your building inspector. The letter from the building inspector should be in your file. I spoke to the town planner regarding that. And as far as the details around the building envelope, we did add a walkway here that allows the egress doors that were located in the two positions here to allow the pedestrian to step out onto the walkway. We did identify where the patio would be with the pool area. We did add additional infiltrated drainage systems associated with that. We did move the proposed generator from the side yard setback and put it to the rear, away from our only really residential abutter here, to the northeast. We added additional infiltrated drainage associated with the roof areas. Did a more traditional HydroCAD evaluation on the stormwater analysis for the site, a much more extensive look at it. That was forwarded to the consultant, and no no issues, correct? Thank you. We decided during construction that we would retain our existing driveway, and we moved our filter strip, if you will, back, so that during the construction window, we would have the ability to use the existing driveway to minimize the tracking out into the street. We did identify that if any tracking did go out into South Avenue, it would be swept. There's actually a little bit of swept analysis that's done here in the bottom right-hand corner of the sheet. And we added a note relative to the landscape architect that's responsible for this job to come out to inspect and to determine what would be the best appropriate vegetation to supplement the existing understory along the tree line. That was something that the board had raised when we had our site inspection. The remaining sheets in the set are the same. We still have our residential plan that's part of the set, and we also have our landscape architect's plan done by Cosmos Associates detailing the proposed plan. So I'd be happy to answer any questions. I'm hopeful that we can bring closure to this evening. Thank you.
Okay. Dave, any comments at all?
No, the stormwater is fine. I kind of forget what else we had to finish up.
It was a while ago.
A couple of weeks.
We need a decision.
Okay. Board members, any comments, questions? Sounds like you said everything we asked him.
Sorry, was there something about lighting that I recall?
Well, we did a detailed lighting analysis.
Right.
We provided that as part of the packet. We're well below your maximum allowable.
Right.
And I believe that, again, I spoke to Joe a little bit about a draft decision, and we talked about some of those details.
Right.
So we're well within your thresholds. More comfortable with that.
Okay. Any comments from the audience? No comments? Close the hearing? Or leave it open and review the draft decision at some point?
There's only one item in the decision that I was actually still waiting for you with, and that was the maximum elevation of the height. They came in, their plan showed maximum height of 29 feet, but the exact top ridge line based on average natural grade, that's just a number that needs to be plugged in. There wasn't any concern about exceeding the height, but that's just a little detail that we can approve the decision with that being filled in.
Okay, that's good. So we're going to continue to what date?
Well, this was continued so that he could get us the revised plans in so that I could prepare the draft, which is included in the packet.
Okay, so we're going to review the draft decision.
If you could, Mr. Chair, this evening, the family that's trying to do this residence, we still have to go before your zoning board. They do have a pending meeting coming up. If you do make the decision this evening, we can make that meeting, and they can possibly get in the ground before the winter sets in. We did start this process, as you recall, back in the beginning of the summer. So it's just the way it goes.
All right.
So if you can find the time this evening, I greatly appreciate it.
This will be the first one where we're dealing with replacement construction on a non-conforming lot, as coincidence would have it. This is not a historical structure, and I guess the question I have is, based on this protocol that we just talked about in this meeting, we need to, I suppose, suggest